Hello, welcome to Facebook Live with Pisgah Legal Services. My name is Jessica Leaven, and I'm an attorney. I work with Grimes, Teich, Anderson in Asheville, and I primarily practice employment law. I represent employees in a wide range of different employment-related matters, and I'm also a volunteer attorney with Pisgah Legal Services. I'm here today because the pandemic has raised a lot of new legal issues for employees and employers over the past several months. Businesses had to shut down, employees lost their jobs, unemployment claims skyrocketed, and now we're in phase 2 of reopening in North Carolina, and a lot of businesses have reopened. State officials just determined a few days ago that we're not in or ready for phase 3 yet, but that may happen in the near future. And Pisgah Legal has recognized that employees would have some questions about returning to work in a pandemic, which is understandable. Those employees have submitted questions to Pisgah Legal Services, and I have also been receiving a lot of calls from employees asking similar questions. So I'm going to address some of those general concerns today. The first question that I have been hearing a lot, and Pisgah has as well, is can I refuse to report to work if I'm called back by my employer to come to work? And I think the general answer in that circumstance is that, employment in North Carolina is at will by default, which means that an employee can quit or an employer can fire an employee for pretty much any reason at any time, unless there is some kind of contract of employment that says otherwise. So generally, if you refuse to report back to work when you're called back to work because of concerns about the coronavirus, employers would generally be free to terminate your employment and hire someone else who would come to work and take your job. But that being said, there are some exceptions to that general rule that I can talk to you about. I think the first general exception would be the National Labor Relations Act, which is a federal law that gives employees, regardless of whether or not they are unionized, they have the right to engage in protected, concerted activity for the purpose of mutual aid or protection. And that could cover a wide range of activities. It could be like a walkout, a strike, or a refusal to return to work. If workers are fired for protesting unsafe conditions, then they could make a complaint to the National Labor Relations Board. But there are some limits to this law. The NLRA protects only group-based activity, so it doesn't cover just one worker that's complaining about their particular employment situation. You have to be complaining about a number of workers, and it's much safer to complain with more than just yourself. An employer can't fire the workers, but they can permanently replace them. So that just puts the employees up to the top of a rehire list. And in general, employees who are refusing to work under these circumstances or striking or walking out would have to have a reasonable good faith belief that their work conditions were not safe in order to be protected. So that is one federal law that could give some protection related to refusing to report to work in an unsafe environment. The second law is the Americans with Disabilities Act, which is again a federal law that protects employees who have disabilities that are defined as substantially limiting major life activities. That covers employers with 15 or more employees, and it requires employers to provide disabled workers reasonable accommodations to let them do their job as long as it does not impose an undue hardship on the employer, such as a financial hardship. So if an employee who is being asked to come back to work has a medical condition that constitutes a disability and puts them at a high risk for COVID-19 complications, then there may be some protections for that employee. The CDC, if you go to the CDC's website, they have a list that includes specific conditions that put you at high risk, and it includes chronic lung disease, asthma, heart conditions, people who are immunocompromised, diabetes, chronic kidney disease, I believe in liver disease. So if you have some of those conditions, then those could constitute disabilities, and an employee may ask for a reasonable accommodation under the ADA. The same thing goes for if an employee has a pre-existing mental health condition or disorder, such as anxiety or obsessive compulsive disorder or PTSD. Those mental health conditions can definitely and have been exacerbated by this pandemic. And those employees may be entitled to accommodations as well. Accommodations can range from a lot of different things, like continuing to work at home or teleworking if that's a possibility. And in some circumstances, it can also include providing unpaid medical leave. So that is another option for employees. Additionally, the Family Medical Leave Act gives employees who have worked for an employer for a year and they work full-time and work at a location with 50 or more employees, it gives them up to 12 weeks of protected leave for their own serious health condition or a family member's condition. So it is likely that all those other conditions we've talked about and even more could constitute serious health conditions under the FMLA, and an employee could go to their doctor, see if their doctor thinks that it makes sense for them to stay out of work, and then request FMLA leave for those conditions. The federal government has recently expanded the FMLA under the Families First Coronavirus Response Act, which is referred to as FFCRA, and that has made, given some additional protections to employers with fewer than 500 employees, and that for certain reasons tied to the virus. So, for example, workers who are the primary caregiver of a school-age child under 18, or they have a person in their household who they care for that has to stay at home because the school or their care facility is closed because of COVID-19, then they can get up to 12 weeks of leave as well. And so if you're being asked to return to work and you're in that circumstance, then you may be able to refuse to do so without being terminated, or with your job position needing to be held for you. And there's also some protections under the FFCRA if you're called back to return to work and you have symptoms of COVID, or you've been asked, or you have COVID and you under self-quarantine, or if you've been ordered to quarantine, then under those circumstances you would have protections from returning to work as well. Another two laws in North Carolina specific could be the Retaliatory Employment Discrimination Act, and then the wrongful discharge in violation of public policy. And those two laws can protect employees in North Carolina from being terminated for refusing to engage in activity that violates set guidelines under OSHA or the public policy of North Carolina. And for this pandemic, there have been some guidelines that have been set. The CDC has set forth suggestions or requirements for businesses. The U.S. Department of Labor has set forth suggestions and requirements. OSHA has guidelines that may apply. There are executive orders that Governor Cooper has set forth with certain guidelines. Even Buncombe County is mandating the use of masks for businesses. So, you know, technically, I mean, there haven't been any cases. This is a new area that we're experiencing. But if an employer is not complying with these guidelines, then employees should raise their concerns. If they're being asked to return back to work, they should say, okay, well, I'm concerned about this. What's being done to address these guidelines? And discuss with the employer that they don't want to return to work unless they're in compliance with guidelines. And if the employer refuses and is actually violating the guidelines, then if the employee refuses to return to work and is terminated, then they may have a RETA claim or a wrongful discharge claim under state law. But the situation is that essentially just because you have a potential claim doesn't necessarily, I mean, I guess I always tell people it's better to have a job than to have a potential legal claim against your employer. I think it's a difficult time for everyone right now. You know, businesses are nervous about reopening. Employees are nervous about reopening. And I think this is a great opportunity for employers and employees to work together and to try to make a safe work environment for people. So I'm looking here and I see a few questions have come in on this particular topic. The first question that I see is this for businesses with more than 50 workers? Normally the FMLA applies, and I think this is what this would be referring to. The Family Medical Leave Act applies to employees who work at a particular location that has 50 or more employees within a 75-mile radius. So that's a little bit complicated, but it typically applies to, and that's just the basic FMLA that protects your own serious health condition and the serious health condition of others. Now, the new requirements under the FFCRA that have just been passed that protect the caregivers of school-age children, or also people who are caring for people within their own household, that covers a wider range of employers. It can be any employer with less than 500 workers, so it can even be smaller employers. And I think there have been some regulations that have passed where an employer can try to get an exception, but I don't think that that's necessarily going to be easy for them to do. So I think most employers are going to be required to provide the leave for those caregivers. I hope that answers those questions. I think from my knowledge, and I see a question here, do individuals caring for aging parents qualify for any exceptions? I think that, and I don't want, this is something that I really honestly do not fully know the answer to, but from what I have read and from what I believe, I think that there could be some protections if they were in your household, but honestly, I would really need to research that, and I can do that just to make sure, because I do think it's limited to your household. Now, the caring for children, I believe that there's a question about whether or not caring for children extends into the summer. And again, this is since many summer camp programs are not running, I mean, I'm in that same boat. I have 2 young kids who are in elementary school. And I do believe that the way that law is set up, it will extend, because those are technically facilities, if they are actually closed, that you were registered for, if summer camps and places that you were relying on are not open, under those circumstances, I believe that would qualify. I think there are a lot of questions about these new laws, and the guidelines and guidance is not entirely clear. They're issuing guidance all the time. So a lot of those more difficult questions I would have to research. Now, Moving on to my second general question, and I've heard this one a lot, is do I lose unemployment benefits if I decide not to go back to work? Now, unemployment benefits in North Carolina have historically been horrific, at least in the past number of years. Frankly, they're bottom on the list for employees in North Carolina. And before COVID-19, to be eligible, you had to be unemployed due to no fault of your own, earn sufficient wages to establish a claim, and be available, and actively seeking work. Governor Cooper has issued several executive orders that relaxed those requirements and allowed people who even had not been working, for a week to still receive unemployment benefits. But the maximum state provided unemployment benefits in North Carolina are $350 a week. That's the maximum, for a maximum total of 12 weeks. But thanks to the federal coronavirus aid, relief, and economic security act, the CARES Act, the federal government has boosted those benefits tremendously. And this is one of the reasons why people are asking this question, frankly, because the pandemic unemployment compensation that you get from the federal government is a flat $600 a week for anyone who's getting state benefits. And that is, that was week ending like in April through, I think, the end of July currently. There's also a pandemic emergency unemployment compensation that extends the state benefits, because the state benefits were limited to 12 weeks, but there's an extension to an additional time period for that, for people who are eligible for state unemployment benefits but exhaust their benefits. And that does not have to be COVID related. And then there is pandemic unemployment assistance, which is a great new benefit, because this allows those who are ineligible for state unemployment benefits to, so for example, independent contractors or self-employed individuals to get unemployment benefits. So because of these, expansion, because of how the United States has chosen to try to give help to workers who have lost their jobs or businesses, there are many employees and self-employed people in North Carolina who are currently receiving, the same or more in unemployment benefits than they received while working. And when you have that situation, I think it can be tempting for those employees to say, okay, look, I'm making more money now on unemployment than I was at work, and I don't want to go back to work. Well, in general, I would not recommend doing that, because in many cases, if you choose to not return to work, you're going to end up losing your unemployment benefits if you were called back to work and you refuse. I think you have to assume that your employer, number one, is going to report this, that you have refused to, a request to return to work. They'll report that to the unemployment office. And employees who are receiving unemployment have to certify in their weekly certifications if they've received a job offer and if they have refused. And if either of those two things happen, then you would not be eligible for ongoing benefits generally. There are some exceptions that I can talk about, but I have a real concern, because I've seen several articles, the U.S. Department of Labor is already discussing this and raising this with Congress, that they are concerned about fraud and abuse in the unemployment systems and the way the states are administering them. So they are in the process of investigating, and I think there is a real concern that if you refuse to return to work without a reasonable, justifiable reason, you might lose your job because you're going to be fired. You might lose your unemployment benefits. And worse than that, too, you could be accused of engaging in fraud. So none of those things are good options. Now, there are some circumstances where I think you can legitimately refuse to return to work and not lose your unemployment benefits. Number one would be if you have COVID-19 and you have symptoms and you are seeking a diagnosis and you have been advised by your doctor not to work. That's a good reason to refuse work. Number two, if you are high risk, and North Carolina has specifically said that if you yourself have one of those high risk conditions that give it a situation where you're going to have potential serious complications with regard to COVID, or you live with someone who is at high risk, and this could be someone who's in your household, and I think this definitely includes, children, spouses, parents. In those circumstances, if you have legitimate safety concerns to returning due to your high risk situation, which also includes being over the age of 65, then you should be able to refuse to return to work and still be entitled to receive your unemployment benefits. If you decide to do this, I would definitely seek, a consultation with your doctor or your family member's doctor. Get a doctor's note establishing what the condition is and, a recommendation that it's unsafe for you to return to work. That will definitely help with the unemployment process. And, if you can't do that, you can always rely on medical records or the CDC guidance. The next thing is, I believe, if you are a primary caregiver of a child or a person in your household whose school or care facility is closed due to COVID, then under those circumstances, you should be able to refuse to return to work and still receive your unemployment benefits. And then also, this is going to be a harder issue, but if you talk to your employer and you express concerns about safety, and you are told that your employer is not going to be following practices, safety practices, then under those circumstances, you may be able to refuse work because the work that they're offering is not, quote, suitable work. So it's unsuitable in some way, and because of that, you should be able to continue receiving unemployment benefits. Now, with regard to that, I sure would want to have some guideline to rely upon, whether that be the federal CDC, OSHA guidelines, or the state guidelines, or the local regulations that have been discussed. Because if you lose your benefits for refusing to work, you have to go through the appeal process, and you're going to be out of a job and not receiving benefits for a while, then that's a concern. So I do not see any questions. Well, maybe I do. Okay, so I saw some other questions that have come through while I was discussing that. And one question is, do you have to share sensitive health documents with your employer in order to get the high risk exemption? What are my rights in protecting my health issues? Normally, the Americans with Disabilities Act, and I'm going to get into that some more, protects, you don't have to turn over documents per se. But if you do have a condition, that is a disability under the Americans with Disabilities Act, which a high risk condition could be, you need to disclose it to your employer or tell them about it for them to be on notice of the condition to be able to give you accommodations. So, you don't have to tell your immediate boss or supervisors, but you typically go to your human resources department or, higher level management, because they protect that information and keep it confidential, put it in separate employment files. They can't share that with anyone else, but you're going to have to let them know, your employer know, if you're going to want to get some protections like and accommodations like being able to continue working from home or getting time, or rearranging your work environment to give you more protections. Let's see, the next question I have is, if you work at a restaurant and you start having symptoms and tell management, but management does not send you home, what should that employee do next? That is a very good question. I think that is incredibly problematic. And I'm going to get to that in terms of the next section that I can move right on into, which is, does my employer have to protect me? And I think that also covers, does my employer need to protect other people that are coming into my business? There are federal laws and North Carolina laws right now that are, that do require employers to provide workers with a safe workplace. So there are a few rules that deal specifically with the pandemic, but the General Occupational Safety and Health Act, the federal and the North Carolina acts require employers to follow safety standards. Some of them, like there are certain OSHA standards, well, there are OSHA standards that govern a lot of different businesses, but they're the ones that govern respirators and other personal protective equipment, and require hand washing in the workplace, like when you use the restroom, etc. OSHA has issued memorandums and guidance, and so has the Department of Labor related to the pandemic, that breaks down different levels of workplaces based on the risk. So you have some low risk places, which for example would be a law firm. This is pretty low risk because we're able to telework. And more medium risk places, which would be restaurants, and high risk places, which are healthcare providers. But I think that the duties and requirements range depending on the business. So there's a general duty that's required under the federal and North Carolina OSHA to provide a workplace free from recognized hazards that could cause workers harm or death. And then there are all the other federal and state guidances as well. So I think that in that particular situation, if you are, that employer is in a situation where if you're having symptoms and you're concerned about it, you need to be able to take the time to go and get tested, find out what is going on, and you should be in a situation where you're not working and they would be required to pay you while you're seeking. I think that the new law requires it's like 2 weeks of pay while you're seeking a diagnosis. But there are also serious concerns with that situation that employers are not really implementing the proper measures that are necessary to keep them, the employees themselves and others safe. Unfortunately, there are always going to be employers that don't comply. And I think when that happens, that's when you're going to need to probably consult with either an attorney, contact Pisgah Legal Services, contact the OSHA division of the North Carolina Department of Labor to raise complaints about safety situations. I think if you have a good faith belief that your workplace is unsafe, then you can raise those concerns with your employer, refer to the different guidelines that I've covered, which would definitely indicate that if you're having symptoms, you shouldn't be at work, and explain your concerns and why things need to happen differently. And, again, getting other employees to complain with you will be concerted activity and give you additional legal protections. I think if the concerns are not being addressed, I would recommend, by the employer, I would recommend making complaints externally through the OSHA division of the North Carolina Department of Labor. You can call 1-800-NC-LABOR. I think there's also an online complaint system and speak to someone there. They can do investigations. Technically, employers are prohibited from retaliating against employees for making such complaints, but frankly, there are a lot of laws that provide protections. That doesn't mean that the employer is going to comply with the law. If you have an employer who is making you work an environment when you're symptomatic potentially and have COVID, it would concern me that they might not be complying with other laws as well. I think you would have potential legal claims against an employer in that situation if you were fired. But again, going back to what I was saying to begin with, it's a lot better to have a job than to have legal claims against an employer. And I'm also concerned, I think that these agencies that I'm talking about making complaints to are likely swamped with complaints right now. And it may take some time for them to complete the investigations. I think that if you in general decide to leave your job because of safety situation, you're going to want to show that you have good cause to do that. And I think you could get unemployment benefits in those circumstances. Let's see the other questions. Let's see. There is a list of there's a list that the Division of Employment of Security Commission considers to be good cause for not returning to work that's on PSGA's FAQ page, which you can see that as well. Now, the next topic that I was going to cover, and this is supposed to be, I guess we're at 30 minutes, frankly, right now, but I had some other items that I will cover as well, and I don't think there's any reason why we can't continue for those who are interested. If you do ultimately decide to return to work and you get sick or have symptoms, and this again goes back to that question that someone had just asked, if you get sick or you're having symptoms, I think you need to immediately request paid time off from your employer. If you need that time off to care for yourself or for a family member who has the coronavirus or symptoms, or you need time off to care for a child who ends up like, you know, maybe they were in some camp and then all of a sudden something changed and the care is no longer there for them, I think that you can request time off in those circumstances and get leave, some paid leave, as well as some additional time off, even if your employer itself does not offer you sick or PTO leave. And this is back to the Families First Coronavirus Response Act, and it requires employers with fewer than 500 workers to give short-term and long-term leave to workers who get COVID or have symptoms or can't work for reasons tied to the virus. You know, this is the first, I mean, there have been a lot of concerns with wanting paid leave, and this is the first time the federal government has mandated that in any way. There's no North Carolina law that mandates paid leave. But under this, workers can take 2 weeks off, so 10 business days, or up to 80 hours at full salary, which is capped at $511 a day, if they are subject to an isolation order, if their doctors told them to self-quarantine, or if they have symptoms and are seeking a diagnosis. So in that circumstance where you're in a restaurant and you are having symptoms, you know, I'd request leave, this paid leave, in order to go get a diagnosis. I think that it comes back very quickly now. There are drive-through tests and you can get your results like in a day or two. So workers can also take 2 weeks off at 2/3 pay, capped at $200 a day, for a family member that is having symptoms or subject to a quarantine or because of schools being closed. And these benefits are built into the Fair Labor Standards Act that govern pay-related issues. But there are, unfortunately, several exceptions to that law, particularly with essential workers, such as those in the medical field, EMS, and police. Now, you can also, of course, that's just the paid leave portion. You can, you know, seek FMLA leave if you have a larger employer and you have, you know, 50 or more employees and you've been there more than a year and you qualify. In those circumstances, you should be protected to take time off of work under the Family Medical Leave Act. And then you also, that has been expanded to protect like 10 additional weeks in addition to the 2 weeks paid if you have a school-age child who's at home and you're having to care for them. So you get partial pay to care for them during that time period. And that is a benefit that's built into the Family Medical Leave Act. Now, again, if you ask for this paid time off or FMLA leave and your employer refuses or terminates you for taking it, then technically you would have a potential legal claim against your employer because, you know, retaliation, the laws make it illegal to retaliate against an employee who's requesting this time off or is being underpaid or denied time off. Now, the other item, if you get sick, that, you know, the Americans with Disabilities Act protects people with disabilities, which again would give additional protections to you if you were having symptoms and you didn't want to take paid time off, or you ran out of your 2 weeks, you know, or if you had conditions and were uncertain and wanted to work from home, or, you know, there are some accommodations that can be requested under the ADA including additional medical leave even beyond the FMLA time period of 12 weeks. So those are the laws that could protect you. Let me look and see. I have some questions. There's a question here about a person who works in the, I guess, a salon, an esthetician who's receiving unemployment benefits as an independent contractor with a high exposure to the virus, who's has a compromised immune system from fibromyalgia, and a husband who's over 65. I think that under that circumstance, I would definitely seek, and I will be clear, I'm not as familiar with the requirements for independent contractors because I typically represent employees, but I think it would be the same. And if that's the case, I would go to your doctor, your husband's doctor, talk to the medical providers about whether or not it is safe for you to return to work. If you have a medical note from a doctor telling you that you should not be returning to work, I think that the unemployment system will, give credence to that. I've had an unemployment claim recently, which was a spousal situation. And in those circumstances, when you have a person who is in those high-risk categories, it always depends on the particular hearing officer, but in general, I think that North Carolina is trying to continue benefits under those circumstances, and I think that you should be able to do that. Let's see. The next topic that I had, I believe I've hit all of those questions. The next question is, can my employer treat me differently because I have symptoms of COVID or get COVID? And I think we're all very paranoid and concerned about, the potential for transmission of this virus because people are unsure how it's transmitted and what to do to protect themselves. And I think in general, my short answer is yes. In these circumstances of the pandemic, your employer definitely can treat you differently if you have symptoms of COVID or get COVID. Normally, the Americans with Disabilities Act prohibits a lot, it restricts medical inquiries and asking questions about people's medical conditions and exams. They don't usually permit it unless it's job related and consistent with a business necessity. Employers usually can't do it unless there's some reasonable belief based on objective evidence that a medical condition would impair an employee's ability to perform their job or pose a direct threat to the workplace. So that's usually the standard. And a lot of times that is a high standard, but the EEOC, the Equal Employment Opportunity Commission, which is the federal government agency that governs the ADA and issues guidance and investigates it, they have issued new guidance regarding inquiries and exams during the pandemic. And there's a whole booklet, you can go online and read it. And during this pandemic, employees are going to have less protections than normal for these COVID-related issues. Employers are specifically allowed to ask employees if they are experiencing symptoms of COVID-19, and that's not something that's typically allowed. And I think we know now, well, there are so many symptoms of COVID-19, it can range from anything to the respiratory common fevers to the COVID toes. So that's very broad in terms of what employers can ask about. Employers can also test employees' temperature, so they can have a thermometer at the door and test people as they come in, which is not something that's typically allowed, but will be allowed now. And they may require employees with symptoms to stay home, or require them to be symptom-free for a while before they return to work. They may require doctor's notes. They can even, I haven't heard of this happening yet, but I've heard some employers are going to be doing it, is specifically test for COVID-19 or antibodies. So I think that's all really going to be allowed. The confidentiality limitations remain in place. They have to keep the results of these tests and the exams confidential. Although employers can disclose positive tests or a COVID diagnosis to public health agencies. And frankly, I think in these circumstances, many employees can always tell their coworkers or tell their employer, hey, you can let everyone know that I have this. I think for everyone's safety, that may happen more frequently than it normally would. This isn't a situation like most disabilities where, you don't necessarily want to disclose like your underlying chronic health condition to people. This is a condition that can actually impact the safety and health of your coworkers, and I think more people are being open and willing to share. But that being said, the ADA does provide protections from harassment, discrimination due to a COVID diagnosis, and you can be protected from termination or adverse actions if you have severe COVID complications and that constitute a disability. Let me see if there are any other questions. I don't believe so. I think the final question that I wanted to cover is that, can my employer treat me differently because I'm in an at-risk category? And I think no is the short answer for that. That's something that I've seen quite a bit of guidance coming forth through the EEOC on that topic. The federal discrimination laws still apply. That includes Title VII, the Americans with Disabilities Act, the Age Discrimination and Employment Act. And, fear of this pandemic or, transmitting the virus should not be misdirected against an employee just because they fall within a protected category. And that would include age, which is if they were over 65, you can't say, no, sorry, we don't want you working here because you're over 65. Or disabilities, if they have one of those underlying health conditions, you can't tell them, no, don't work here because of that. If you're pregnant, that is definitely a category that puts you at risk, and you can't discriminate against people because they're pregnant. And I think there's been a lot in the media about, and I've read a lot of articles about whether or not there is an increased risk for males or African Americans or Hispanic minority populations. You can't discriminate against people based on those categories because you think that they might be at an increased risk or you're afraid. So employers instead have to continue to do like a direct threat analysis like we discussed previously, and an assessment. If it's a disability related issue, they have to consider whether or not some accommodation could be made. Like if you have an employee who is over 65 and they're in a very open position, you might want to, talk with them and have a conversation about what can be done to protect that employee. And if they are in high risk, you might want to consider, putting up some sort of barriers to protect them or allowing them to do telework or a different job. But you can't basically require a person to go home or not work or fire them because of those reasons. I see we are beyond the time frame, and I have one more question that has come in. Let me see. This is an unemployment question that says that the person's been out on unemployment and conferring with their employer about returning to work and when they're going to hope to reopen. He said that there would be no masks allowed. Temperatures would be taken at the start of every shift, gloves, sanitizer. And you're asking about whether or not you think it's safe to go back to work. I can't specifically answer that question for you. I can't give concrete, direct legal advice exactly about your circumstance here today. I can tell you about what the general rules are. And again, the Division of Employment Security Commission has several items that they have listed where you can, if you refuse because of your health condition or certain related circumstances, and they're set forth on PSGA's website. There's an FAQ section. Under those circumstances, you can refuse. But I'm not sure, under these circumstances, I'd have to look at your health condition, if there's a risk to you, if there's a risk to someone in your family, if there's something that the employer that is doing that is a violation of the OSHA or CDC guidelines, and it's just unclear from your factual scenario that you proposed that that would be the case. So, you have to go through that whole analysis that I talked about previously to see if there could be a reason to refuse to come back to work before doing so, so that you won't end up losing your unemployment benefits. I hope that this was helpful today, and I know that this is a lot to cover and there are a lot of questions about this. I think that the U.S. Department of Labor has a lot of helpful guidance and fact sheets related to some of these employment issues that we've been talking about today. The Equal Employment Opportunity Commission, the EEOC, has a lot of guidance that's available online as well. And again, PSGA Legal Services has guidance. You can contact PSGA directly. They're helping people out now on unemployment-related issues. So they have attorneys who are helping handle unemployment questions and field those and even handle some claims. And again, when they have situations that they do not cover, they will refer out to volunteer local attorneys like me, so that if you qualify for PSGA Legal Services for free, they may be able to put you in touch with a local attorney to be able to help you with your situation. So again, everyone, please stay safe. It was a pleasure doing this. I hope that you're able to return to work and coordinate with your employers so that we can get businesses open again and, people can start working again, but do everything we can to protect employees and customers and everyone in this difficult time. Thank you again.